You're welcome back. This is Newsfile, it's the most authoritative news analysis platform, and here on Newsfile we put Ghana first. I'm seeing the many messages you are sending to me now, but my take is not for discussion. So we don't discuss my take. Yeah, that's what we do. We hold secrets and we push paper. When it's not time to say certain things, we don't say them. So thank you very much. It's my truth, I am telling you. My guests on the table here, I've just showed them the evidence I spoke to you about. The evidence I spoke to you, I just showed to some of them. They've watched it. Now, Senya Hosea is convener, the One Ghana movement, and trustee of the Ghana Coalition Against Galamsey. Bobby Bansing is joining us via Zoom. He is lecturer at the Ghana School of Law at Makola. John Darko, Johnny, my very good friend. He's MP Swami. He's been at this for a long time. And then when your time is up, your time is up. Time is just up. He's MP Swami. He's member subsidiary legislation committee of Parliament and legal counsel for the minority. It appears it's the very first time you have designated counsel for a group in the House, right?
Well, I mean, this is the first time I'm going to the House, so...
Right. Because I've never heard about that there's counsel for a particular parliamentary group.
Yes,
it's an interesting one.
Yes.
Okay. Also here is Victor Kojoga Adaudu, used to be on this show many times, many years ago. He's managing partner, Lord and Lords, and he's a member of the NDC Legal and Communications Committee. Thanks for making time to be here. And here, in his usual style, is Kwame Boafo Akufo of Ekropong Ekwaping. That's how he wants to be introduced. Kwame Boafo Akufo, Esquire of Ekropong Ekwaping. I've seen him celebrate our tradition and our heritage in ways that you can't help but admire. You know, that the elite will find time to celebrate our culture. Gentlemen, welcome to Newsfile.
Thank you.
Thank you.
Great. So let's begin straight with the matter of Kpandai. And the EC has eventually, after receiving the notice from the Clerk of Parliament, then also issued a release saying that on the 30th of December, there will be a rerun. I've spoken to people who don't believe that rerun will happen because they are thinking about the pending matters that are all in court and among other things, even suspecting that there will be further legal, processes that may be mounted. Let's begin with John, because you are coming from Parliament. You were so unruly in the House. The speakers, different speakers could not bring you to control yourself in the House. And as John begins to speak, we'll show you some of the footages of what happened in Parliament. Okay. Yes, John.
Okay.
Why?
Well, I mean, I disagree that we were so unruly. In fact, protest is part of the democratic rights that we can exercise on the floor. This is not the first time we've seen that on the floor of Parliament. And so let it not seem as if the NPP is the first political party to protest against a decision by either the Speaker or the Clerk of Parliament. It's a legal process that we are allowed to, and we did that. And our reasons, are very simple. I mean, the day before, our leadership had gone to see the Speaker about the Kpandai matters, and there were assurances that, because they had hints that such a letter was going to go to the Electoral Commission, and they had the assurance that no such letter would be written, especially when there were so many applications and processes, which the Parliament itself had been served with. The Parliament had been served with the application for stay of execution. The copy of the appeal had already been served on Parliament, and of course the application for certiorari had also been served on Parliament. And so there was that assurance that no such letter would be written to the Electoral Commission, only to come the following day to see that the clerk to Parliament had virtually declared the seat vacant, something which we felt was completely wrong and unjustified. And we had to protest, and it is one of our rights. We did not take arms, we didn't take stones, we did not take cutlasses to the house to kill anybody.
The kind of manifestation by way of opposition that we are used to is that you take a walkout. If your voices are being muffled or you are not, you walk out. But here you were, you refuse to walk out, and then you say business will not be conducted in the house.
There are so many ways of making your case. I mean, you can choose to advise somebody to walk out. We will choose to stay and make our views known. And I think that it is our right that...
that was disruptive.
No, it wasn't. It was our right that we properly exercise. Look, I think what is wrong, what you should condemn is the fact that in spite of our protest, they sought. And I would say sometimes even illegally to do business, and because we had committee reports that were not signed, that were taken. I mean, they used only one microphone and they were doing all kinds of things. You should condemn that. And sometimes it's only okay when, you feel that it's okay to criticize a minority. You should criticize the majority for the position they took. You should also talk about how the speaker presided over that case or something. Maybe he should have adjourned. He felt that he wanted to do what he felt was okay for that.
You raise the grounds for an adjournment. And the speaker, you raised all the processes for adjournment.
Yes.
And you didn't succeed. You failed. So you ought to have worked out rather than...
We didn't think that was the case. We thought that staying in and making our case was a better option. Look, we in this country, we've seen something similar. I don't know whether you've seen the videos. You can show videos. You have one on your phone. Have you seen videos where the NDC, led by some judge, we're marching on the floor of Parliament? Have you seen that? You should show that as well.
When was that?
Oh, come on. Are you telling me they haven't seen that video, my brother?
No, I'm asking you, when was that?
Well, it wasn't easy, obviously. When they were in opposition.
Okay.
When they were in opposition.
And what
they
did
were
you
marching.
say?
They were marching.
And what did you say?
I didn't say anything. You were here. I don't know what you should remind yourself what you said then. And then you can also...
What I said then is what I'm saying.
But I don't remember.
I
didn't see your position.
This is unruly.
But I think that, look, we live in a very democratic society. I mean, your description of what happened, of course, it lies within your mouth, and that's okay. But I think that so long as we engage in a lawful protest to bring our views across, it should be okay.
Okay. So you attempted to stop proceedings on the basis of lack of quorum and so on, and you lost all of that. And then you decided that this is what you were going to do. Seyon,
yes.
What did you see and what do you say?
But I
briefly, we'll get to the substance.
Yes.
We'll go to the substance. Yes.
I mean, John is bad. I came here very excited because these are all my brothers.
Yeah.
He doesn't believe what he's saying.
No. When
you were talking, I didn't talk.
I don't say I don't believe.
I say you don't believe what you are saying.
Okay, so
you do not. You are not somebody who
saying.
subscribes to that kind of conduct.
What are you talking about?
I agree with you any day. You are entitled to some form of protest. But when you're putting that thing on live TV, and you have our children, your children, and our children's children see our parents act this way, what kind of governance are we trying to communicate to the world? It's not something anybody sitting here would ever condone. Let's be careful. There's some bickering going on in Parliament, and you guys must start rising above it and stop acting like children. You're acting like kids. There should be some adult in the room and make sure there's proper order in Parliament. People watch you on live TV, and you guys are supposed to be the creme de la creme as far as governance in this country is concerned. We learn from you. The tone of this country is driven by what we see. You are the leaders of the country. You can't come and defend us here. You should be apologizing to us, the people, for misconducting yourselves. It's not the first time. We saw that in the last parliament. And I think that it's now unbecoming of the political elite, which should be driving our governance and shaping the trajectory of our culture and our dealings as a people.
Senor, what could they have done? They got into the house. They wanted to be sure there was a quorum to begin the business.
Yes.
Then there was a voice vote whether they should go on or not. And then they raised an objection. The minority whip raised an objection that they would rather take a, what do you call it then? Sorry, you call it something, you do a division or something.
Division, yes.
You get to a point before you ask for a division, right?
Yeah, we do voice
after
vote. And then if we protest, and then we do the...
So your whip asked for that to be done.
Yes.
And the speaker, who is supposed to rule, took the view that as far as he was concerned, those who wanted to continue business carried the day.
But we see
so
maybe
what were they supposed to do?
Before my brother even comes in, what you've forgotten is that this whole thing, we had a peaceful protest. Look, the disruption, the proper disruption you're talking about, came as a result of our brothers on the other side moving to our side. We were on our side. They the ones who moved in because we had moved, we had congregated. If you can see,
we had us in the room. We watched it on TV.
We had congregated
this
at our
is
side.
the party.
They
of
were the ones who came.
J.H. Mensah. That is the culture we see. That is what we learned.
Your group got up first.
Yes, but they came to our side. They came to our side.
No, I thought what we saw. It was as if you were trying, after you were banging on the table and throwing your papers, it didn't seem to get you sufficient noise to mute the carrying on of business. Then you moved. Yeah, and fearing that you were moving towards them to their side, which is actually an anathema. You can't do that.
No, but they came to attack. They came to attack us. Maybe you should show that part of the video where,
my brother, if all of you were sitting down in your corner
to attack us. Oh, so you justify that and blame us?
I'm not justifying anything. I'm blaming the two of you all.
You are saying that if we were sitting on our side, this
I said if all of you were sitting in your corner,
calm down, my
there'll be no problem.
Calm down. You calm down. Calm down.
People should stop the shouting.
Calm down.
You started this in vetting, throwing and breaking tables. And you know what? This is a function of the leadership we are now getting from Bagbin. Respectfully. It's my man.
So you see what is seeing. What we are seeing on the screens now appears to have been the approach they took initially, just banging the table, shouting to stop the majority from being able to carry the business, and then later they get up and begin to move. But he is saying in their movement they didn't intend to cross.
Yes.
But the majority took the view that they intended to cross, so they too got up to try and cordon them off. Yes, Victor.
1 second. See, look at what happened during the vetting. Has there been accountability since then?
Yeah.
Where is it?
They set up a committee.
You understand? And where did that end? Because they know that we'll talk about it 1 week, 2 weeks, and it's dead. That is the kind of parliament that we are nurturing. And frankly, it is telling on the leadership that we are getting from Honorable Bagbin. He's ending on a bad note. This is his last term. He's never going to be speaker again. And if it doesn't bring proper order and bring in a parliament that has a lot of new people, shape the culture for governance and for posterity's sake, we are not getting that from him as speaker.
That's an important point. The so-called committee that sat and heard over the vetting chaos, which led to destruction of public property, nobody is being held accountable for that.
Samson, let me say good morning to our viewers and good morning. It is unfortunate and it's sad that we see our political elite, who must know better, that in Parliament there will be fisticuffs, in Parliament there will be exchange of words, banging. On this very... One of my sons at home, they said, Daddy, see, do elders fight? Look at them fighting there. And he said, Daddy, is this the place, Parliament, you say you want to go? You have to go and be fighting. This is what he said. I was surprised, I was shocked when he said that. I think that it doesn't augur well for us at all My language may be a bit stronger. You know, the Gans have a saying that Onupa Beshiano.
Ow.
It just to it is that is no adult or adults in the house. You know, there are tools of protest in Parliament, and it is accepted. But I don't think that these tools are steeped in violence. They are not steeped in violence that you can be banging the tables.
So banging the table is violence, right?
Oh, why would in a civilized society,
so why
when you want to make a point...
So why did your party members cross over to Kpandai?
No. Before the party, the even majority came. There were the marshals.
Yeah,
the marshals were called in. Yeah. It is a resemblance of what even happened on 6 January 2021, where the soldiers instead of the marshals were called in. It's almost the same thing. And this is becoming a blot on the conscience of Parliament. I believe that this is a time that it must be condemned. That the fact that it was done by the minority during the previous administration, it should continue. And this is the way we have to disrupt. I believe that Parliament has come too far. Our democracy.
The majority has realized that they will talk, they won't get listened to, and they will walk out. And then they will continue what they are going to do. That's why they decided that we will not walk out, because walking out is to give you room to do whatever you want. That's why they stay.
Once you can stay, you can protest. Once you are there and you say we will not contribute, we are not going to cooperate with you. That was what we told. We were told that there's not going to be cooperation.
They said government business will suffer.
Yes, government business will suffer. So sit in there, make your protest. You don't need to raise your voice to be heard. You don't need to raise your voice to be heard. And you see both sides. And because there's no precedent that people who get involved, apart from maybe the speaker mentioning the name to shame the person or mention the honorable member that I can see you, you know, there should be some form of punishment or sanctions, because it's becoming too many. We have seen this in our parliament. And if people are sanctioned, members of parliament are sanctioned for displaying some unparliamentary behavior, I believe that this will come to an end. My brother Senyo said, everybody respects Speaker Kpandai for the depth of knowledge, the experience in handling parliament. I think that he has relaxed. In the eyes of the public, he has relaxed too much.
Failed or relaxed? How many incidents has he set up committees?
Failed.
Remember what happened to Zenator? He said we're going to, what has come out?
Nothing has come out of it.
So too many times we hear of a committee, but nothing comes out of it.
Comes out. That's why I'm saying that he has
They're taking Ghanaians for granted, right?
He has worked his credentials, respected everywhere within the world, Africa. He should not end on a bad note. That under your leadership, we have several infractions within Parliament and nothing had been done. I think that will not go down in history, and it will not be in favor with him.
We need to get to the substantive matter. And let me bring in Kwame Boafo Akufo now. Yes, you must have seen these footages.
On the contrary, I refrain from this Pontius Pilate approach of condemnation of people in Parliament. I've never been in Parliament before, but I can speak to the law. To be able to understand these matters, it's important for us to be able to look at the future of the past. And when I say we have to look at the future of the past, we have to look at the prevailing law or the precedential value of judgments, decisions, and practice on what led to the situation. We are here confronted with a situation in which a court of law has made an order that a rerun should be done in respect of a constituency. Parliament and all other organs of government and the citizenry are bound by that decision of the court. In fact, Parliament as lawmakers are not supposed, or they are not entitled to undermine the integrity of a binding judgment. Until the judgment is suspended, or vacated, or overturned for that matter, that judgment is binding on Parliament. Now we have to keep in mind two things. Unlike a private matter where a stay of execution will be in the form of the Moffat rule, where when there's a stay of execution, it's akin to an order and people have to stay their hands. In the constitutional dispute, the mere pendency of an application for stay of execution does not necessarily stop the constitutional clockwork.
Yeah.
We are therefore to contend with a situation where the Clerk of Parliament's attention has been drawn to the judgment of the High Court. All members of Parliament, the majority and the minority, are bound by the constitutional clockwork. And therefore, when the Speaker declares the seat vacant, he is acting in accordance with Article 112, Clause 5 of the 1992 Constitution. Even with respect to chieftaincy matters, when there is an application for an injunction against the chief, unless a formal order has been obtained, the chief will continue working or conducting himself as a chief, for the very simple reason that he's integral to the administration of the governance at the local government level. And that's why judges like Amadou Tanko JSC and Kolendi JSC have stated that because we do not have preliminary filters as to the frivolity of cases which come into our courthouse, in constitutional matters, unless a formal order has been secured, the mere pendency of it can cause confusion. Let us imagine a situation where on the 6th of January, on the 7th of January, John Dramani Mahama, His Excellency, or Nana Akufo-Addo, His Excellency, is on his way to get sworn in, and I file an injunction. Can you imagine the confusion it will cause? Therefore, in the wisdom of men like Kolendi JSC and Amadou Tanko JSC, they have thought that it is proper that in constitutional matters, there should be, the situation should not be that the mere fact that there's a pendency of an application holds the clockwork back. Under the circumstances, the clerk was constitutionally correct. Whether it was constitutionally convenient and practical for governance is another issue. Yeah. And that's a matter for the sociologist. For we lawyers, we know that the constitutional vacancy having arisen, Parliament was obliged to respect the laws of the land. And the clerk was therefore supposed to follow the constitutional network. My understanding is that applications have been filed to restrain the execution of the judgments. Those applications are quite clearly likely to come on before the election is run. Yeah. And I'm quite sure the courts will do the necessary. So within the milieu, within the matrix of facts, we have to ask ourselves, how do parliamentarians react to the constitutional clockwork when it's activated? Because in the near past, we have seen parliaments apply this principle in the Jamson case, the Asini matter. Jachi case. We have seen that the courts applied, and there was applause on this side of the divide. We applauded it. We thought it was okay. But the law must be universal for everybody.
In the Jachi case,
yes,
I think there was an order.
That is correct.
Served on Parliament.
That is correct.
And that's why they insisted.
That is correct.
That since the clerk was seized with the order,
yes,
he ought not be sworn in.
I'm distilling the presidential value. And that's why I started off by saying, to understand the situation, we have to look at the future of the past. Because there has been an incremental accretion on this matter. If you look at the Justice Tokono case, for example, these constitutional issues with respect to the pendency of an application for stay of execution was discussed. The question which arises for thorough and fundamental consideration is, does the clock stop because there's a pendency of an application in a constitutional matter? The Supreme Court, we may disagree with the court, but the court says no, it doesn't. And therefore, as lawyers, we are obliged to respect that and to advise our clients accordingly. Before we had this discussion, our attention was drawn to the fact that there's a certiorari application because the Gazette date has been gotten wrong and the respondent seems likely to win finally. Under the circumstances, what we should be doing is to ensure that we engage the judicial organs of state to bring this finality to the dispute before the 30th. And that's what we should be working on. Once we've decided that our constitutional clockwork will not be interrupted by applications, we must also ensure that we have constitutional servants in the terms of the judiciary who will ensure that the litigation comes to an end before irreparable harm is done. Because if the election is held on the 30th of December, considering the monies that we spent in Akwatia, for example, 38 million cedis, it will serve no useful purpose. Statements have been made to the effect that why is, for example, the Parliament not waiting because of the money which has been spent?
Right.
But there's a constitutional clockwork. And the constitutional clockwork obliges the clerk so to act. That constitutional clockwork should also make provision for speedy and expedited justice delivery when these matters are urgent, and the courts have risen up to that occasion. The courts can even sit on Saturdays and Sundays.
I'll return to you with a
Yes.
question. Let me go to Bobby Banson, but I'll
Yes.
return to you with a question. What the clerk was doing
Yes.
is pursuant to Article 112, Clause 5, where it says, whenever a vacancy occurs in Parliament,
Yeah.
the clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurred. So once the Electoral Commission received this,
Yes.
it means the time had begun to run. Once the Electoral Commission received it, within 30 days, the elections ought to be held. The Electoral Commission has gone ahead to issue the notice that there will be elections in that constituency. Scholars like Professor Kwekwaza disagree that a vacancy does not occur until the High Court has pronounced that there is a vacancy in fact. But in the circumstances, he argues that the pendency of the appeal, pendency of the stay of execution application, pendency of the certiorari application, now we understand there's a contempt application also pending. All of these mean that a vacancy in fact has not occurred. Therefore, it is prudent that everybody should hold back pending when things will be done.
Yeah,
That is the view that Patricia Pierre-J, the deputy minority leader, also raises in Parliament. Yes, Bobby Banson.
Before Bobby speaks, let me just make a statement. I take the very respectful position that when a judge makes an order and says that there should be a rerun in a particular constituency, consequential to that order is a vacancy.
Okay.
In law.
Okay. All right.
Consequential to it.
All right.
And
All right. Let me go to,
Let's go to
Bobby
Bobby
now.
and listen to Bobby.
Hi, Bobby.
Good morning.
Good morning.
Samson.
Yeah, I understand
was
that you
listening
are
to-
going to teach very soon, so speak to us. Straight to
I
the
was
substantive
enjoying
matter.
the Senior Kwame. I always love to hear him speak.
Thank you.
You know the way he does it, both in the courtroom and outside the courtroom.
Chew your speech already.
Yes, Samson. Yes, your question.
Yes, so I'm asking, having heard him,
No, this is my notebook for
do you think, people are asking very basic questions, that we have precedents of these issues having happened, but there was an allowance for the judicial process to be exhausted before a vacancy was declared.
Yes, Samson, I am happy that you read the constitutional provision. I think that we must have this discussion in the light of the petition that was filed to the High Court, the orders made by the High Court judge, and the subsequent processes that have been filed, all in the context of the provisions in the Constitution, which is the foremost law, and the Representation of People's Representation Law, as we have it now. I think that if you read the judgment of the court, the judge ended by saying that it is in the light of the various written submissions that I hereby order a rerun of the Kpandai parliamentary election to satisfy the constitutional requirements of free and fair and transparent election result. Now, that was the definitive order made by the judge. However, if you look at the reliefs that the parties were seeking, like Senior Kwame just mentioned, there is no way the judge would have ordered for a rerun unless the judge had granted the previous declaratory reliefs that the petitioner sought in those suits. And those declaratory reliefs essentially saying that there had been irregularity that had been so fundamental in the organization of the elections that there is a need for a rerun. And the judge explaining why he thinks that the argument of the petitioner must hold, concluded by ordering a rerun. Now, per the constitutional provision, once this is done, Parliament is notified, the clerk then writes to the Electoral Commission. This is a constitutional mandate that process must be undertaken. And as Senior Kwame said, in the most recent cases of the former Chief Justice, Justice Stokono, the Supreme Court seemed to have emphasized without any doubt that where there is a mandate placed on an institution by the Constitution, that mandate is not suspended unless there is an express order so to do. And so if you look at what the Clerk of Parliament did, by writing to the Electoral Commission, letting the Electoral Commission know that they've been served with this order, my understanding is that the clerk was following due processes or obligations, carrying out an obligation imposed by the Constitution. If you look at what the Electoral Commission did, that they have announced that there will be a rerun, then you would say that Electoral Commission is also carrying out their constitutional mandate. However, if there have been judicial processes that have been filed that seeks to restrain the carrying out of these constitutional mandates, the question is twofold: whether it is legal for this mandate still to be carried out in the light of the pendency of the of the court processes, and second, whether or not it is, Senior Kwame used the word prudent, to still carry out these mandates in the light of the provisions. Now, Samson, if you look at the certiorari application that has been filed to quash all the proceedings leading to the judgment and the judgment itself, the argument being made, and I don't know if the Electoral Commission has been served, if the original petitioner, who will be the interested party in the certiorari, has been served, the argument being made that the petition was filed outside the time limit provided by Section 18 of the Representation of People's Law. And so if that actually is upheld, it means that the petition was filed was a nullity. The processes filed leading to the judgment itself was a nullity. Everything that had been done by the court itself is a nullity. Now, if the Electoral Commission proceeds to order a rerun on the 30th, and the certiorari application finds favor before the Supreme Court, and the Supreme Court quashes all the processes leading to that judgment and the judgment itself, what happens to the rerun if a new person has been elected by virtue of the rerun? We are going to find ourselves in a constitutional crisis. I am aware that the return date for the certiorari is the 16th of December. I expect that on the 16th, the Supreme Court may be moved by counsel for the applicant in the certiorari application for the Supreme Court to order the Electoral Commission to stay the carrying out of the rerun on the 30th, pending the outcome of the certiorari application. That is, if the certiorari application would not be determined on the 16th and it has to be adjourned. I think that we must also commend the judiciary for giving such a short date to the certiorari application so that it will, to all intents and purposes, be heard on the 16th before the 30th December, which day the Electoral Commission has put across. So I think that there has to be a legal question that has to be answered. My position is that it's looking at the decision by the Supreme Court in the Tokono case, it seems that there will not be any constitutional restriction on EC or the clerk carrying out their duty. But on the side of prudence, the side of prudence and the consequence, if they proceed with the rerun and the certiorari in particular succeeds, what will happen if a new MP is elected by virtue of the rerun? The rerun is based on a judgment that the Supreme Court may subsequently order to be a nullity. We'll find ourselves in a constitutional crisis.
Why constitutional crisis? The court will simply say that the judgment of the High Court is vacated, and therefore the status quo before will remain. Yindam will simply go and continue his work, even though we would have wasted if we spend up to 38 million, would have wasted 38 million organizing fresh elections.
That's a lot of money, but I'm talking about the crisis in the event that if the decision on the certiorari is not delivered before the 30th, a new person other than the MP who is the subject of the dispute is elected. He is sworn in by Parliament. He goes through all those legal processes. Now, Supreme Court says that the judgment based on which there was a rerun is a nullity. It means that that person who will now be affected by the Supreme Court decision, but was not originally made a party to the certiorari application, would also have a recourse. That is the crisis I'm talking about. Because if a new person is elected the decision on the certiorari will affect the person now. But that person will not have been a party to the original certiorari application because at the time the certiorari was heard, he was not yet elected. And so it's looking at all these matters. It may be in the interest of justice because justice must not only be done, it must be seen to be done. And to avoid some of these pitfalls that may occasion if the rerun proceeds prior to the delivery of the ruling in the certiorari, I think that the applicants may have to move the Supreme Court on the 16th. That is, if all the parties have been served with the certiorari application, and if the Supreme Court is not going to deliver a ruling on the 16th, pray the Supreme Court to stay or order the EC to suspend the rerun until the outcome of the decision in the Supreme Court.
Okay, as I understand, the EC, they have been served, they have responded, and there is an application in the direction of what you are suggesting to suspend.
In the Supreme Court.
Yes, to suspend the direction for 30th rerun pending the hearing and conclusion of that matter. But from what you suggested, as we understand, the 24th December date, Gazette, that appears to be a question no longer in doubt, as confirmed by the Electoral Commission and previously by the Supreme Court in the Akwatia, election dispute matters. So from where you sit, does it not look most likely that the courts will, as it were, uphold the argument by Matthew Yindam that the Tamale High Court did not have the jurisdiction to hear the matter?
Well, Zamzi, we can only speak to the law as we understand it, and the facts would have to, but we will leave the conclusions to the judges. Otherwise, we may be cited for attempting to discuss. But like you said, if there's no doubt from the previous decision in the Akwatia MP case, and you see the counsel, Gary Nimakun, was also cancelling the matter of Eskumi.
That's right.
In the Akwatia, where he argued that if the 24th is the day of the Gazette, then per Section 18, the petition ought to be filed within 21 days. And if it is 21 days, if you look at the Interpretation Act, includes Saturdays, Sundays, and holidays. Because the Interpretation Act says that if a statute requires a thing to be done, and that thing ought to be done for days less than 5 days, then it excludes weekends and holidays. But if it is more, it includes weekends and holidays. And it says that 21 days from the date of the Gazette. It means that you start counting the 21 days after the 24th. So even though the 25th is a holiday, by virtue of the Interpretation Act, it will be calculated and all other holidays along the line and all other weekends will be added. And if you add all of those, you ask yourself whether the petition was filed within the 21 days. The Supreme Court has made it clear where a statute provides for timelines and you miss those timelines, you cannot invoke the jurisdiction of the court. And so it's a question that you would have the Supreme Court applying the law as they have in the past.
So your wish is that we slow down, or as it were, Parliament and the EC slow down. However, the way to get things slowed down to 30th of December ought to be by judicial means. That's what you're saying.
That is what I think, that the Supreme Court must make a native pronouncement. Because you see, hitherto, we had thought that the mere filing of a certiorari, if you look at cases like Ioko, the mere filing of a certiorari operates as a stay of execution until the Tokono decision where Justice Kulendi made that point and forcefully so, that when we do that, constitutional machines may be grounded by frivolous applications, for lack of a better word. And so you'd have the Supreme Court having the need to go the extra mile and making definitive pronouncement that as long as this certiorari is pending, they are ordering the Electoral Commission to stay their hands until the final determination for all the reasons that I have sought to submit.
Thank you very much. Yes, please do.
Mr. Bobby Banton for his contribution. Let me just say this very respectfully.
Actually, there is a lawyer, Angelo Ramon de la Cruz. He says vintage Cotobrija Kwame Boafo Akufo Esquire. I love him. Brilliant submissions. Newsfile always does the do. One of these days, I'll post my first experience of Kwame Akufo in court. He's suggesting that after your presentation, your submission, we should end the discussion on this subject.
I beg you. I've got people here. I beg you. Let me just make a point very quickly. The same Supreme Court, in canvassing this learning, has also told us that if the underlying substantive matter displays manifest disruption of the constitutional order, you cannot claim to be running a constitutional clockwork. And therefore, the court will injunct if a party is able to meet a high threshold of showing that the substantive case is very likely to succeed. In this case, if the Supreme Court still wants to abide or still seeks or will abide by the Akwitia decision, that will mean that there's a very high regard or high probability that the application for certiorari will succeed. In such an instance, the court will grant an injunction. So while the learning is that the mere pendency of an application does not injunct, if you are able to show and meet the proper threshold or the proper gravity that indeed you have such an underlying substantive case, the court will not allow it to go to waste. So under the circumstances, despite the position of the Supreme Court, there's a caveat which allows persons to come through that narrow pinhole to be able to injunct matters.
Right.
That then is
right. And so, I was talking to you and your concern was, it's an election matter, so why are we not doing it like the Daddy Lumba kind of case? Fast.
Absolutely. I mean, it doesn't make sense to me why we should have too much of a problem. So I absolutely align with Kwame's position. Because look, this thing is not an NDC MPP matter. It's really about our democracy and our governance structures. It's about how the various institutions of state can work in harmony.
And it presently causes a security threat in the area.
It does, absolutely. And thankfully, it's not as though the die is cast. There's a window to harmonize the worries of the MPP and the activism of the NDC, which I also am quite alarmed by. The NDC does not need that seat to exercise its political, dominance.
Because they already have two-thirds majority.
It already has a two-thirds majority. I was hoping to see a more calm and focused structure or response to it. But you see, the bickering, and forgive me, but the childishness that's going on in Parliament, where people are fighting over anything right from start, is what's creating this. Everybody wants to show how he can dominate you. Somebody says, I'm a mighty minority. You're a minority. Somebody is a majority, wants to show that it's a super majority. You're just a majority. So let's just work in harmony. We have a perfect opportunity to showcase the brilliance and the beauty of our democracy. Parliament is moving. Let's work together. What I want to see from the MPP is actually making a case to the judiciary to ensure we don't create this constitutional crisis. That is unnecessary. Because come Tuesday, which is the 16th, this matter can be resolved. So how do we make sure that our judicial system is woke to the reality of the urgency of this particular matter? The same judicial system that was able to summon and panel a whole bench for the Afenyo versus Speaker case, in hours. All right? I don't know why they took this time. All right? But this is a real constitutional crisis. So we should see that attitude. The people of Kpandai deserve representation. And that representation needs dignity and certainty. We can't turn their votes into a revolving door. Now they vote today and tomorrow they say the vote is no more. And by the time they come back and say, okay, we have to come back and vote. It's not fair to the people. And more importantly, we are stoking up a certain security problem which we are already struggling to manage.
Victor, imagine that even the appeal process, if we follow just the appeal, and it ends up by saying, oh, they came to court complaining about 41 polling stations. So we set aside the High Court ruling and order that, in fact, there were infractions in those 41 polling stations. So the 41 polling station, there should be a rerun there. At the point, we would have already done the election or would have already spent unnecessarily for the whole constituency.
Yeah, but Samson, yes, I understand the sentiment and the law, what it's saying. But I just want to make it clear that what is being done or what we are seeing does not mean that we are not operating within the confines of the law, right? Even Section 19 of the People's Representation Law even gives the High Court the power that you certify there's a warrant case which directly goes to Electoral Commission, right? So if there's a rerun, there's a warrant that goes straight to Electoral Commission. Now, Electoral Commission issued the writ because the lawyer had filed a contempt application that order has been served on you. That Section 19, what it says should be done, has been done. That also comes, so what actually the clerk did is not.
So as we said, there's a contempt application by the petitioner.
By the petitioner.
Against the Electoral Commission.
Electoral Commission.
For not acting fast.
Because the warrant has been served on.
They filed it before they got to know that the EC had issued that there was going to be.
I think the following day that it was issued. Right? When they filed it, I don't know whether they were served, EC was served when they issued it, or EC issued the writ.
I think it was the same day. They filed it, and then by evening, we got to know that the EC had already, issued a release saying that there will be elections.
Yes.
So let's say that one is already overtaking.
Now,
then we are talking about another contempt application, either by the respondent, right?
Respondent.
The respondent, that is in the Supreme Court now.
Right.
That saying that EC should not have done that. And, there's a certiorari that has been filed. If you go through the genesis of this case, there is a competing gazette, another gazette that was done on Monday, the 6th of January.
Let me clarify. The contempt by by Martin Yindam is against the Clerk of Parliament.
It's against the Clerk of Parliament.
Yes, right. Go on.
It's against the Clerk. Now, the genesis of this matter was that
when it is at the Supreme Court.
Yes, when the petitioner filed earlier, right, believing that it was the 24th December, the respondent, Martin Yindam, came to court and said that it was premature because there has not been any gazette. And now brought out the 6th January gazette, right? Then they withdrew the application out of abundance of caution. So from 21st, 21 days from 6th, right? That was when they filed the other one. So it's an issue of two computing.
But was not successful. His application was dismissed.
Yeah, no, his application was upheld. That was premature. When they brought in the 6th January Gazette.
Okay.
Right?
Okay.
6th January Gazette. So from 6th, 7th, they could now have their 21 days. That was when they filed the petition. Now the issue is, at the time when the court's jurisdiction was invoked, was it proper? Before the Supreme Court now comes with the Akwetia case.
What does it change?
No, if the Supreme Court, if at the time...
Let me just interrupt you. Let me interrupt you.
You said it is...
The reason why I will interrupt you with respect is because constitutional law does not allow for estopel. Yes. And therefore, you cannot have an accrued right in unconstitutional matters. And therefore, the Supreme Court's latter decision will pretend to pervade and undermine the reasoning that you are trying to urge. That's why I'm interrupting you.
Let me interrupt.
There is no estopel.
No, there's no estopel.
So don't say it. Understand the principle of estopel. But I think you are communicating to the public. We should break that down.
Yes, I want.
So I'm interrupting you.
I am sorry.
Maybe I don't even want you to.
I am sorry. I want my learned friend to understand.
What you say?
I want my learned friend to understand.
What
that he shouldn't push the argument. I'll be done soon. Let's make it tidy. I'm just trying. You shouldn't push the argument that the jurisdiction of the court was invoked at the time that there was some gazette of said this, that. At the end of the day, the Supreme Court took a position on the matter, and that position on the matter undermines that constitutional structure on which the High Court began to operate. Because there's no estopel in constitutional adjudication, it will not work. It will have been unlike, it will have been unlike that if it was a land case. It was a normal contractual dispute. But in constitutional matters, we will not canvass this. Let's not urge this learning and muddy the waters of clear constitutional streams.
Kwame, I agree with you, but what I'm explaining is that
Yes.
it is not that it was just deliberate that the court at the time knew that I didn't have jurisdiction.
Nobody said that.
No. You see, that is what is being urged in public, that the time limit.
Who is
right?
urging it in public?
No, but if you see the certiorari,
Yes.
the certiorari says that the time limit, it was wrong. And I want to say that the lawyer who filed it is such an experienced lawyer that he knows that time limit and statutory fees would have to be paid.
What has it got to do?
No. What? That's all. So that it's not in the mind of the public that they knew that the time had expired, and they went and filed, and the court assumed that jurisdiction.
But it may have been an honest
this is adjudicating the substantive matter.
No, that's why I want the public to understand that. As lawyers, what you are saying, I understand it. But I just want to make the point.
Tell the public that the Supreme Court has ruled on this matter. Tell the public that the Supreme Court has ruled on this matter.
Yes,
but tell the public.
That later Supreme Court ruled on the matter.
Say so. Thank you very much.
But in the mind of the public, it will be like the lawyer and didn't know.
Why are you holding brief?
No, I'm not holding brief. It will be like the judge who even presided over knew that he didn't have.
It could have been a trap. And if they were successful, they were successful in obstructing you.
But as lawyers, I know that, as you said, there's no estoppel in that. Supreme Court has decided. Now it is left with Supreme Court with this application going to make a decision.
So the point we're making, I was suggesting
we
to
always
you
see as if having some legal.
If the NDC candidate went to court, and then Matthew Yunam came to court and said, "You have come at the wrong time."
Yes.
And then showed him that this is when you should have come. And he took that bait and went at that time. It still doesn't stop Yindam from coming to say, EC has confirmed, Supreme Court has authoritatively affirmed that 24th is the actual date. Yeah. So even though you took my whatever, I don't care.
Yeah, John. So Samson, so why would the EC have two different dates for Gazette? The Electoral Commission, you have to Gazette the results. Why should it be on two different? What is the mischief?
You see,
no. You see, what is that? Is it a mistake? Is it a mistake?
It's a legitimate one.
Is it an issue of mistake? That is to say. I'm saying that
court has an opportunity to pronounce on this.
Exactly. Because the fundamental human rights of the parties involved.
Are you getting? The people of Kpandai will want to know. Of course. That when was the result gazetted? Was it on the 24th? Victor, I'm coming.
Let us speak as lawyers.
Oh, no.
Let us speak as lawyers.
Why?
Because you veer from the law and then get into political propaganda, which you're very adept at. It's not about what the people of Kpandai are thinking.
That there have been two gazettes?
No.
Is it a fact that Kwame? Is it a fact that there are two gazettes?
Keep it tidy.
No. Is it a fact
it
that
is
there are
the law
two gazettes?
that the Supreme Court says the Gazette date is the 24th. Inform the public accordingly.
But don't
this
to be revisited.
Are you getting?
Now, but the court has been different. This is, I think it's July judgment. The judgment was in July or June.
This matter has been resolved. Kwame has given us the direction.
Yes.
Let the court decide quickly.
You have a legitimate question. I was going to, for me, I'm familiar with the 24th Gazette.
Yes.
I'm actually putting it up so that all of you can see the Gazette notification by the Electoral Commission dated the 24th of December for the election dated the 7th of December. And I'm using the specific one on Kpandai, Bimbila, and a couple others, but I'm showing them to you right now. John?
Yes.
So, at least you have heard from Kwame and Bobby that it does appear that your only wriggle room is a judicial process that will slow this, and not what you did in Parliament.
I mean, I don't know why,
and not all the noise you have been making.
No, they've grown up now.
Let's understand it. The judicial process you're talking about is not the only option for us.
Kwame says
No,
the court has
it's
made
fine.
an order.
Yes.
We are all bound by that order.
Yes, but it doesn't.
Are we not?
It doesn't preclude us from exercising other judicial rights.
No, you say the clerk has done wrong.
No, so,
EC shouldn't be doing what he's also doing. The question is, what did they do wrong? They only complied with the court order.
I think that we have moved forward in this discussion.
Yes.
We have shown, I have told you here, that we firmly believe in what they did. We brought the views of us to the people of Ghana. We expressed our displeasure.
You mean you are now realizing that
No,
the only room for you to stop any process is through a judicial process and not making noise in Parliament?
No. I'm saying that going to court, we are in court. So we know that going to court is one of the options. It's not the only option.
And you know that you don't have an order from court to stop the process from going on.
My brother, we have made...
Why are you telling everybody that they are doing a wrong thing when they are not doing the wrong thing?
We believe that the certiorari application that was served on the speaker was a very valid one, and that should at least slow them down. We believe that the application for
the speaker is not party to any process in this case.
When I say the speaker, I'm talking about Parliament. I mean, it's a clerk to Parliament.
Parliament is not party to the process, is he?
The clerk is the third defendant in the Kpandai case. Is a clerk to Parliament.
Kpandai case.
Yes. You should look at it. The
Kpandai case has two defendants.
Oh, there's a third defendant.
It's the Electoral Commission.
No.
There were actually four initially.
The clerk to Parliament.
And the two were then, as it were, disjoined.
No. So
okay.
the clerk, maybe I'll show you that particular one. The clerk to Parliament.
No, I've seen the judgment. Okay. Do you see any third defendant on the judgment?
I'll show you, because there's one I've seen. But quite apart from that, the clerk to Parliament is an important part of this whole discussion. And that is why it is important that when we file an application before the Supreme Court or Court of Appeal, the clerk to Parliament is made aware. And so the clerk to Parliament is no mean a person in this whole
argument. An interested party.
Very, very much so. So we inform the clerk to Parliament that, look, we have this application for certiorari seeking to annul the whole process, okay, the petition up to judgment. So the clerk to Parliament was aware. And then we made a case that, look, if you look at the fact that the declaration of vacancy, in our view, hadn't completed because there's still the appeals, okay? And so the clerk to Parliament was wrong in saying that
just
there's
a second.
vacancy.
Just a second. This is the Gazette notification I was talking about. It's
yes.
Gazette notification.
Which number is it?
Gazette notification number 8123, Ghana Gazette, 24th December 2024. And Victor, as I understand it, the 6th January Gazette only covered the constituencies which were outstanding, like in Sawama, Drojiri, and Techiman. It did not include
but maybe
this other place.
Let me finish.
That's
maybe we can come back
okay.
to
That's okay.
And I think that when it comes to the Gazette, the Supreme Court has made its decision. We have filed this certiorari application knowing very well that we have a very solid ground. Because I think the judgment, I've looked at it, page 7. It is page 7 of the Supreme Court judgment that actually says that this is a valid one as compared to the January 6th Gazette notification. And so if this is the valid one, and it is 24th December, and the petition is filed on 25th December, clearly the petition was filed out of time.
You know,
the petition was clearly filed out of time.
Don't litigate that anymore, because the lawyers who can be impartial in this matter.
But I don't think. Anyway,
wait, hold on. Relax. The two of them have said that from what they see, it does appear most likely that Nyindam may get a favorable decision in the certiorari. So don't let us litigate that. I ask you a specific question.
Yes.
That there's no order stopping the clerk, stopping EC, stopping Parliament or anybody from proceeding to respect the orders of the Tamale High Court. So why are you there reading statements upon statements and disrupting everything?
That's what I'm saying, that whilst the court processes are ongoing, we as a political party, or for us as a caucus in Parliament, will not sit idly by. We have a constitutional right to protest, and that's what we did. I don't think there's anything wrong with that. I don't know why you keep. I don't know why something. I don't know why something. No. I don't know why something keeps going back. But it's something. It is something that keeps going back.
You should be remorseful that what she's being condemned in Parliament.
It is.
But if you take that position, that arrogant position that we are right. You have the right.
You don't decide. You don't decide.
But you see,
you don't decide what
the
we
whole
do.
what you people all did, both NDC and NPP,
Okay.
was wrong.
You don't
Okay,
decide.
thank you.
Thank you.
Thank you.
And so I'm saying that something.
Thank you very much.
There's 6 Gazette, 6 January.
So you have my point.
You have Kpandai in it.
I see.
Kpandai in it.
Okay.
So I don't make notes.
I need to go to I need to go to Bobby because he has to go and teach.
Okay.
All right. Because we are having larger streams of law students. The teachers have to teach on Saturdays and Sundays.
About this law matter because it's a governance matter. Now the EC is an institution of state, a constitutional institution. If the EC has issued 2 different gazettes, and me with my human rights to be fairly and legitimately represented, me to also with the right to actually contest an election and actually defend the outcome of an election if I feel that there's any challenge or any legitimate one, and it's benchmarked to what the EC is supposed to do, and he has issued 2. Are you guys telling us here
Supreme Court has decided that one is valid?
No. Are you?
And the Supreme Court says the 24th December one, which is valid.
He's not talking about that.
I'm not talking about
He's not talking about the legalese.
I'm think about it. If I take my actions benchmark against that gazetted documentation from my institution of state, which is so authorized to do so, which is dated state, how then do you want to hold me responsible for the mishap of the EC? You are vitiating the right of the Kpandai people to be legitimately represented.
All right.
You are vitiating the right of the NDC guy to also have.
Thank you. Thank you. Let me go to Bobby. Let me go to Bobby now. Hello, Bobby.
You can have 2.
Right. So, Bobby, what will be your concluding comments on this? I thought you actually effectively concluded your comments about it, gentlemen. But because you have to leave also, the OSP and abolishing, you may make your comment briefly and then take leave of us.
The OSP, I agree with the President, His Excellency, when he said the call for its abolition is premature. We must accept that the OSP office, the law itself came into being in 2017, less than 10 years. There is no institution or state that achieved optimum efficiency within 10 years of its establishment. I'm not saying that the office of the OSP has excelled, but I don't think that it has failed. I think that as an office that is statutory, we would have to...
But Bobby,
yes.
Has the OSP done 10 years?
No. I'm saying the law itself was passed in 2017.
Right.
So the law itself is not even 10 years old.
Well, the office actually started operating sometime in 2018. Yes. I think with Martin Amidu, 1 other and 3 other people. But they didn't actually operate. And then it moved to the next year, 2019. It's 2019 that they had their regulations passed, which they were asking for a long time, right?
Yes.
And then eventually they moved from one office to the next office until they got this office they are in now.
Where they are now. That was even with the staff that they had. Yeah. So they had people on secondments. We heard them in the media saying they need time, their own permanent staff to train them. I think that we should, and you see something.
So they completed the staffing sometime in 2023 before the end of 2023 or 2023, 2024 thereabouts.
And so effectively, it's only been effectively set up in terms of its staff, all the training and everything for a very short time. And my worry is that the narrative for the OSP to be scrapped is actually being trumpeted more by politically exposed persons and politicians. But the law that was passed, the OSP, is targeted at them. And if the citizens allow them to have their way, because there was a reason why the OSP Act was passed. It was to fill a certain lacuna in the prosecutorial powers of the Attorney General. And we all agree that because the Attorney General is a political appointee, until the office of the Attorney General is decoupled from the Minister of Justice, there may not be the political will for an Attorney General to prosecute members of his own political party. There have been few exceptions, but it has not been the norm. And so if we insist on letting the OSP go because there has been one or two unfavorable court decisions, then I ask myself, what happens to all other state institutions that we have invested money in since independence, since we became a republic, that we keep complaining have not been able to meet up their obligations? I think instead of trumpeting only the weakness of the OSP, as citizens, as the media, as the politically exposed persons, we should look at how we can contribute to making the OSP as an institution. And I think a lot of the narrative has been directed at the persons in charge, instead of looking at the institution that the framers of the act sought to establish. Ghana is not the only country that has an independent prosecutor with this mandate or with this framework. In a lot of countries, they have succeeded. And like I said, the law was passed less than 10 years ago. Effective establishment of the office, from what something you have said, is less than 2-3 years. And so I think instead of always trumpeting their failures, because the Attorney General's department has not always gotten away with prosecutions they have done. Does it mean that we should dissolve that department? No. Other state institutions, IOCO, there was a Supreme Court decision that caused investigations done by IOCO, and even, for lack of a better word, blasted their heads for attempting to be or allowing themselves to be used for private engagements. All those things are recorded. We've had issues with Shraj. A lot of decisions that Shraj took were set aside by the High Court many times in the past. Does it mean that Shraj has failed? And I feel, sadly, that the only reason why there's a lot of talk about this, going away with the office of the OSP is because the OSP, as it stands now, seems to be the only independent institution with the will to go up, or let me say with the statutory opportunity, let me put it that way, to go after politically exposed persons and their cronies. Now, if we allow it to be as independent as it should be, if the politicians and the politically exposed persons allow the office to operate without any form of influence whatsoever, remember their mandate was that they are supposed to carry out their duties not under the direction of any person. It's in their law, not under the direction of any person. Then if we allow that to be, then I think that in years to come, the OSP office will be one that we will be celebrating. That is my contribution on that point.
Okay, thank you very much. And that's the note on which I'll take a break and return. But factually, I'm holding the OSP laws here. The parent law is Office of the Special Prosecutor Act 2017. Don't let that deceive you. This says 2017. Now, let me read to you the date of Gazette. That means the date it came into effect. Date of Gazette notification, 3rd January 2018. 3rd January 2018, even though the law is labeled as 2017. And then they needed rules, or what we call legislative instruments, to work with. They had 2 of them, all of them done around the same time. So Office of the Special Prosecutor Regulations 2018, and then you have Office of the Special Prosecutor Operations Regulations 2018. All of these were gazetted and entered into force 22nd December 2018. Gazette notification 26 November 2018, entry into force 22nd December 2018. So you can properly count, start your counting if you want to look at when the office started from December 22nd, 2018. I also have the bill when it went to Parliament here because I was following it a lot. We'll take a quick break. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. Those of you talking about my outfits, from the place where you get the best of kaftans, that is Habil's Couture. You can find them on their social media handles, or you can call 0200 84 1988, 0200 84 1988. And as you know, this show is brought to you by the kind sponsorship of Bank of Africa, strong as a group, close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance. Dial *165# on MTN to join My Way today. Syntax Tanks, it's strong, it's tough. Activa International, our clients are passion. International Facilities Management Association, they are proud to be associated with your most authoritative news analysis platform, Newsfile. Safari Valley Eco Park, that's the place you must be these holidays, bringing you closer to nature. Valex Lease, your affordable documents management solution, and Gold Ball Jewelry, pure, precious, proudly Ghanaian. So let's get back to the next issue that we have, that is the Special Office of Special Prosecutor and the matters coming up about it being scrapped or not being scrapped. My guest still here in the studio, Sonia Hosi, convener, One Ghana Movement and trustee of the Ghana Coalition Against Galamsey. Bobby Bansin had to leave us because he had to teach. He is a lecturer at the Ghana School of Law at Makola. John Darko is MP, former teacher also, member, Subsidiary Legislation Committee of Parliament and Legal Counsel for the Minority Caucus. Victor Kojoga Daudu, he is a lawyer and member of the NDC Legal and Communications Committee. Kwame Boafo Ekufu Esquire of Ekropong Ekwapim. Thank you all very much. I've seen your many messages. I'll take some time to read a few of them, but I think we should move to the next issue. Nonetheless, I need to read just these ones. Alfred says that the Supreme Court in Republic versus High Court ex parte Millicom Ghana Limited and others 2008-2009 2 Ghana Law Report at page 1446 held as follows. Under Rule 27.2 of CI 19, when an application for stay of execution was pending for hearing, it stopped execution until the same was heard and dismissed. End quote. It is only in respect of application for injunction that the Supreme Court has recently held that it will not operate as an injunction until the application is granted. And even here, it is limited to the performance of constitutional functions. So ex parte Moffat is still good law for all other cases. My view is that the pendency of a stay of execution operates as a stay no matter the nature of the case. So that is a view that states emphatically on the basis of a Supreme Court decision that the stay of execution should operate as a stay. Kwame.
In the first place, at the time that this decision had come, the new decision of the Tokono matter is 2025.
Yeah, this 2008-2009. Millicom.
At that point in time, the distinction between constitutional matters and private matters was yet to be discussed by the Supreme Court. Furthermore, the Supreme Court
says that that distinction is made in respect of injunction applications and not a stay of execution.
A stay of execution halts the process. An injunction halts the process. Consequentially, you have the same advantage. And therefore, you cannot read the Supreme Court's position in a literal manner.
Okay, thank you.
Maybe something, let me also you see, with the establishment of the CI 132, it changes the dynamics of CI 19. So we should read it.
But something,
okay.
one note.
Thank you.
We should commend the High Court judge nonetheless. This case was resolved within the year. If I remember George Amu, who was our MP when we were in school. All right, look at what happened to him.
Yeah, George Amu.
I remember
George Amu's case It was not like one case in one court that dragged over the life of Parliament.
In fact, otherwise, Ladi
Right.
or so, there have been a number of them, and they really, this, at least within the year we've had this.
They're right.
I would really encourage the politicians. I don't know if it's another CR, whatever it would be. The same way we corrected the problem with the presidential
Correct.
petition, we should
Correct.
do the same
Right.
with Parliament.
So the CDD has been making a lot of
Nice.
proposals for that. They've actually submitted a proposal. They submitted to Justice Gertrude Tokono. I know because I was part of the process. And as we understand, they may work around it so that election petitions will also be dealt with expeditiously like presidential election petitions, parliamentary election petitions. All right. Randolph says that Section 10 of PNDC Law 284 lists instances where vacation of seat of an MP is postponed. The list does not include a situation where an appeal is pending against a decision of the High Court declaring an MP as not having been validly elected. Article 99 also doesn't create any automatic stay when an appeal is pending. Okay, so all of these are against Professor Kukwazan's views that he has expressed. The express mention of exceptional instances where vacation of seat is suspended lends support to the argument that the requirement that a seat should not be declared vacant pending appeal is not applicable to the Kpandai case. This is more so when one considers that the High Court has done a merit-based analysis and come to the conclusion that the sitting MP was not validly elected. This effectively means that the election of the affected MP is void ab initio. Yes, Kwame stressed that earlier. To argue that once a stay is filed, it should operate as such is to give the litigant judicial power, and all one needs to do is to file a stay and go to sleep. Thanks, Randolph Chumesi, for that view there. Thank you very much. All right. I have a general who is commending Samson's take today. And as I said to you on that take, I've said that there are generals who knew about the assassination attempt and all the arrests, including interior ministers who knew about it.
The former president.
Who knew about it. And those who are still arguing, why didn't they report to the nearest police station? Really?
How can a special prosecutor, an attempt at his life, be police station matter? Okay. And not rather a Danfari matter or an IGP matter or a presidential national security matter?
Okay. Musa Abato and Aswasi says the MPP and their surrogates have no moral justification to condemn the Speaker's action on vacant seats. You cannot approbate and reprobate. What was acceptable when it suited you cannot suddenly become wrong when it no longer does. We are all aware of what happened as regards the Jachi Singh case. The posture clearly exposes hypocrisy and dishonesty of the NPP. Okay. It's a long one, Prof, but let me attempt. Prof Boateng says, the recent happenings in Parliament are unfortunate and deserve sober reflection. Disagreement is a natural part of democratic life, but it must always be guided by restraint, respect for process, and institutional maturity. When tensions escalate beyond these boundaries, the substance of the issue risks being overshadowed by the manner of engagement. Parliament's strength lies not only in a robust debate, but in the collective commitment to uphold dignity, order, and the long-term credibility of the institution. It is in moments of disagreement that leadership is most clearly tested. May wisdom, calm, and respect for democratic norms prevail in the interest of nation and future generations. Thanks for that message. Okay, and that's where I'll end it. Thank you very much.